Welcome and good morning to commissioners and commission staff, the witnesses, and the public watching and listening. My name is Malcolm Morales. I am the staff director of the U.S. Commission on Civil Rights. The briefing will come to order. This is a briefing of the U.S. Commission on Civil Rights, and it is titled The Civil Rights Implications of Cash Bail. It is 10 a.m. on Friday, February 26, 2021. In the absence of a chairperson for the commission, I will appoint a moderator to administer today's briefing. I appoint Commissioner Norma Cantu. Commissioner Cantu, you may now proceed to moderate and conduct the briefing.
All right, thank you. Commissioners virtually presented this briefing. In addition to me, are Commissioner Agdegbile, Gladney, and Yaki. I note for the record that the staff director and the court reporter are present. I look forward to our briefing today and note that we have commission business scheduled for later, but that meeting has been canceled. So to repeat, I'm Commissioner Cantu, and I wish to welcome everyone to our briefing. The civil rights implications of cash bail. The commission will review the state of bail and pretrial detention practices, including the involvement of the private bail industry, various mechanisms for reform, and the potential regulatory role of the federal government. The briefing will examine how cash bail impacts the fair administration of justice and whether it operates in a manner that denies equal protection of the law to individuals on the basis of race or another protected class. Commissioners will hear from subject matter experts such as government officials, academics, law enforcement professionals, advocates, and impacted persons. Panelists. Please note that we have sufficient time for our discussion this morning. I will enforce the 5-minute time limit. Please monitor your time so you don't risk my cutting you off mid-sentence. My fellow commissioners and I will do our part and keep our questions and comments concise. Today's briefing features 14 distinguished speakers who will provide us with a diverse array of viewpoints. Panel 1 will consist of speakers who will discuss the foundations of the cash bail system and the legal basis for its operation in its current form. Panel 2 will consist of criminal justice stakeholders. Panel 3 will consist of presenters that will discuss reforms. During the briefing, the speakers and the panelists will have 5 minutes to speak. After each panel presentation, commissioners will have the opportunity to ask questions within the allotted period of time, and I will recognize the commissioners who wish to speak if they would raise their hands, please. In order to maximize the amount of us and one another by keeping our questions and comments concise, please ask only one question at a time, though I understand that some questions might involve multiple parts. If we all abide by this arrangement, each of us will have multiple opportunities to ask questions of each panel. So with those bits of housekeeping out of the way, we will now proceed to the briefing. I turn to Commissioner Gladney for opening remarks.
Thank you, Commissioner Cantu. Since our nation's founding, we have wrestled with what, quote, excessive bail, close quote, is understood to be. And have cycled through many iterations and regulations governing when release on bail is appropriate. Today, the Commission continues in this effort to understand how to achieve justice in the pretrial system. Our examination of civil rights implications in cash bail takes a look at the several different state systems, all taking different paths to the same aim. Equal justice under the law for people of every race and economic circumstance. We all know our criminal justice system currently does not achieve this goal, And today we discuss how bail decisions are made, when bail is required, and who has access to pretrial release as one way to understand how the system can be more fair to all. The constitutional standard of never jailing someone merely for poverty must be adhered to. The courts must require a high burden of proof before determining individuals cannot be released. We will hear from experts on litigation, interpretations, legislative changes, and practices to make the constitutional guarantee a reality for all communities across the country. Through our research thus far, I have not understood bail to be a partisan topic, and instead have seen actors from both parties, as well as prosecutors, defense attorneys, judges, and community advocates, all coming to the table with ideas on how to uphold constitutional rights and protect the public safety. I hope we, as a bipartisan independent group, can also carry that spirit forward. It takes many people to assemble a briefing like this, and I'd like to thank former Chair Catherine Lehman for bringing forth this subject and her special assistant, Ruku Singla. I think they did an extraordinary job on this matter. I'd also like to thank Staff Director Mauro Morales, Pam Dunstan, Tina Louise Martin, Merrick Xavier Breyer, Angela Roerson, and of course, my special assistant, Amy Royce. I'd also like to welcome General Counsel David Gans, the newest member of the Commission's team, and many others on our excellent staff for their hard work. Thank you, Madam Chair.
Thank you, Commissioner. Let me introduce the people on the first panel. Our first speaker this morning is Insha Rahman, Vice President of Advocacy and Partnership with the Vera Institute of Justice. Our second speaker is Rafael Mangual, Fellow and Deputy Director of the Manhattan Institute. Our third speaker is Kanya Bennett, CEO of the Bail Project. And our fourth speaker is Lars Troutman, Resident Senior Fellow at the R Street Institute. Ms. Insha Rahman, would you please proceed?
Thank you. My legal career started as a public defender in the Bronx. And over the years, I watched hundreds of times as judges, without asking what someone could afford, would set bail on people I represented. And each time I wondered, did the judge set bail at $500 or $1,000, assuming that the person would make it and be released? Or did they set bail assuming that it would result in detention? And in the Bronx, you can bet that 9 times out of 10, someone remained behind bars, likely until they took a plea because they couldn't afford the price of their freedom. One of the fundamental problems with money bail is that it obscures the intent of the judicial decision. Did the judge intend release or intend detention? And yet bail is set hundreds of times every day in precincts, courthouses, and jails across this country. Close to 500,000 people are in jail right now because of bail they cannot afford. I'm grateful to this commission for convening today and for the opportunity to testify. My name is Insha Rahman, and I'm with the Vera Institute of Justice. I've worked on bail reform across the United States, from drafting legislation and policy to conducting research and technical assistance in places as varied as New York, Texas, California, and elsewhere. Increasingly in this country, there's consensus that the US for-profit bail system is an outlier and that money bail itself is a relic. I've been working on bail reform for years, and I believe we're at a tipping point in the fight for pretrial justice. This hearing is so timely. We know from research and experience that money bail systems harm Black people and poor people. A recent study of bail decisions in Miami and Philadelphia, for example, showed that bail than on similarly situated white people. And when bail was set, it was set at higher amounts, on average by $10,000 more. The ills of a for-profit bail bond industry, whose primary purpose is to turn a profit, almost $2 billion a year, are by now also well documented. We've seen several states, Illinois, Kentucky, Wisconsin, and Oregon, more recently, Washington, D.C., New Jersey, and New York, either eliminate or greatly reduce the industry's pernicious reach. Just this week, Illinois became the first state in the nation to sign into law legislation that will once and for all end money bail. The US bail system itself was built centuries ago on one key precept, which is that a financial hook would compel people to appear in court if released. Yet the notion that you need skin in the game has turned out to be a fallacy. We've demonstrated that money bail is not the most effective incentive to get people to show up to court. Places like Washington, D.C., New Jersey, New York City, that release most people pre-trial and infrequently use money bail, have court appearance rates of 88% to upwards of 90%. In New York City, where money bail and the bail bond industry still exists, court appearance rates remain the same for people released on their own recognizance or under non-monetary conditions compared to people released after paying bail. Equally importantly, research and experience demonstrates that money bail has no correlation with public safety. Of the jurisdictions that keep pretrial statistics, typically less than 2% of all people released, either on their own recognizance, under non-monetary conditions, or on bail, are rearrested for a violent felony offense during the pretrial period. I want to raise, though, another equally important, often overlooked serious civil rights concern when it comes to bail reform and pretrial justice. Yes, money bail is a relic and needs to go. It is a civil rights concern. But the excessive use of pretrial detention in this country is another important and critical civil rights concern to address today. Across the federal pretrial system and in almost all state systems, for the past 50 years, the two justifications for imposing bail or detention are, first and foremost, risk of failure to appear, and second, risk to public safety. Bail is set or detention is imposed on one of these two bases. Yet we know that we can manage the challenge of court appearance through effective community-based pretrial services and supports, and that actual danger or harm to the community upon pretrial release is rare. So then why do we continue to use bail and pretrial detention at such excessive rates? It's really that past cannot be prologue in this country. Here are three important reforms that the federal government can enact that will lead the way for states to follow. First and foremost, the federal government can implement mandatory release without bail and without onerous conditions for the vast majority of people arrested. Second, the federal government can help to incentivize and build out community-based supportive systems of pretrial release. Third, and this is important, the federal government can eliminate failure to appear as a basis to detain and tighten the standard for risk to public safety so that public safety is no longer such a broad concept that sweeps up in all sorts of conduct, including conduct that is not actually harmful or dangerous. The main barrier to holding us back is fear-mongering. And we have seen time and time again that fear-mongering causes bail reform to be rolled back. I will name specific instances in the Q&A of where we've seen that happen and where it actually undermines bail reform. But the key thing to remember here today is that the US is an outlier in our use of incarceration and punishment, and that we need to roll back bail and the excessive use of pretrial detention in order to have a system that is fair and just for all people. Thank you.
I'm sorry. Thank you, Ms. Rahman. Now we will hear from Mr. Mangual. Please proceed.
Thank you, commissioners, and to the commission staff for the invitation to speak here today. The issue of bail reform, like most issues of criminal justice, indeed like most issues of public policy, is an important one with major implications for both individual liberty and public safety. Getting pretrial justice wrong can mean more defendants unjustifiably spending unreasonable amounts of time in American jails, but it can also mean more American citizens being criminally victimized by pretrial releasees who should have been, but were not, remanded to pretrial detention. Balancing these concerns for the rights of defendants on the one hand and the safety of communities on the other requires parsing complicated questions. So what I'd like to do in the limited amount of time that I have here today is to make three basic points that I hope will help frame discussions about bail reform moving forward. The first of these points is that pretrial justice systems that rely heavily on monetary release conditions, i.e. cash bail, can and often do place undue burdens on both individual liberty and public safety. In a cash bail system, you can end up with a situation in which a relatively dangerous but well-off defendant can essentially purchase his release despite his risk of reoffending during the pretrial period, while a relatively harmless but indigent defendant gets stuck in pretrial detention despite posing very little risk of reoffending. This, in my view, illustrates one of the strongest arguments in favor of reforming cash bail systems. However, that a particular system is in need of reform does not tell us how we should go about reforming it. Like with virtually any public policy decision, bail reform involves trade-offs. On one side of the scale, you have the liberty interests of criminal defendants. On the other, you have the public security. Simply expanding pretrial release for its own sake is, in my view, the wrong way to approach the worthwhile endeavor of mitigating the risks of unnecessarily jailing defendants who pose little risk of either reoffending or absconding. Unfortunately, this is precisely how my home state of New York has gone about reforming cash bail. A number of analyses have linked pretrial release with significant increases in rearrests during the pretrial period, as well as increases in failures to appear. One paper published by researchers at Princeton, Stanford, and Harvard looked at the effects of pretrial detention on conviction, future crime, and employment of a sample of more than 400,000 defendants in 2 large urban counties. And what they found was that pretrial release sharply increased the likelihood of rearrest during the pretrial period. Another paper by researchers at the University of Utah found that the more generous release procedures put into place recently in the city of Chicago led to a 45% increase in the number of pretrial defendants charged with new crimes and a 33% increase in the number of pretrial defendants charged with new violent crimes. A more recent study of Chicago's bail reform by researchers at Loyola University Chicago found that the rate at which pretrial defendants in that city reoffended essentially remained constant after the reforms went into effect, meaning that the increase in the number of pretrial defendants translated to an increase in the number of crimes committed by that population. And nationally, a study by the Bureau of Justice Statistics looking at those convicted of violent felonies across America's 75 largest counties over a 12-year period found that 12% of those convicted committed their crimes while out on pretrial release. Which brings me to my second point, which is that a fair and more efficient way to approach pretrial release decisions is to make it so that those decisions turn on the defendant's risk rather than on a defendant's wealth, so that dangerous defendants can be detained no matter how rich they are. And this is what the federal government did in the Bail Reform Act of 1984. And that particular aspect of the act was challenged under the Constitution, and it was upheld in 1987 by a 6-3 majority of the Supreme Court, which held in U.S. versus Salerno that, quote, the government's regulatory interest in community safety can, in appropriate circumstances, outweigh an individual's liberty interest. In other words, while there is a tension between the presumption of innocence and pretrial detention of defendants who have not yet been convicted, the Constitution does not require forbidding the latter to serve the former. The best way to go about reorienting the pretrial decision around risk rather than wealth is to give judges access to validated risk assessment tools that can assist them in making such determinations. The best such tools have been demonstrated to accurately, albeit not perfectly, distinguish between defendants with low and high risks of both reoffending and absconding. They do this by attaching certain weights to a variety of factors such as criminal history, age, and employment status. However, these tools do not have to be the be-all, end-all of the pretrial release inquiry. One can certainly foresee circumstances in which it would be both just and advisable for judges to make decisions that might seem incongruous with a recommendation, and they should retain the discretion to do so. My third and final point is that one of the reasons bail reform has become such a pressing issue is the amount of time that people stand to spend in pretrial detention, which is almost purely a function of the resources available to state and local governments to swiftly move cases from filing to disposition. Simply put, better funding our criminal justice system so that they can afford more prosecutors, more judges, and more public defenders is the most direct route to shortening pretrial detention periods, as well as to ensuring that truly speedy trials become the norm. And this is where the federal government can play a role. Approaching bail reform with these points in mind may not completely eliminate the concerns at issue in this debate, but such an approach would almost certainly do a better job of balancing them. Thank you.
Thank you, Mr. Mangual. We will now hear from Ms. Bennett. Please proceed.
Good morning, commissioners. Again, my name is Kanya Bennett, and I am the Senior Policy Counsel and Legislative Coalition Manager with the Bail Project. Commissioner Cantu, while I appreciate the promotion, I am actually here on behalf of our CEO, Robin Steinberg, who sends her regards and is disappointed that she cannot be with you today. The Bail Project is thankful for this opportunity to appear before the United States Commission on Civil Rights to discuss the civil rights implications of cash bail. And it is a pleasure to be in the company of the distinguished experts you will hear from throughout the day, including those on this panel. As this nation reckons with racial inequality, the Commission is right to consider how cash bail instigates the criminal legal system's disproportionate impact on people of color. With these racial justice implications at the forefront, I would like to use this time to tell you a little bit about the Bail Project's ongoing efforts to assist those without the means to pay cash bail, as we simultaneously work towards systemic pretrial reforms that eliminate the practice. The Supreme Court has held that in our society, pretrial liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. Yet people in pretrial detention now make up more than 2/3 of America's jail population. And on any given day, nearly 500,000 people are in jail. They are there because they cannot afford to buy their freedom. They have not been convicted of a crime. And in the midst of a pandemic, we know that the difference of being free or in jail can be life and death. As with all other areas of the criminal legal system, cash bail entrenches systemic racism. We know that Black and brown people disproportionately represent those detained pretrial, accounting for 50% of the pretrial population nationwide. And if a person is Black or brown, a judge is likely to set bail in an amount that is twice as high as the average bail set for a white person, thus increasing the likelihood that they will plead guilty and forfeit their right to a trial. This disproportionate impact is reflected in our work, the Bail Project's own statistics. Our client population is 67% Black and brown. It is to advance racial as well as criminal and economic justice that the Bail Project has been operating since 2018 to intervene around cash bail, one of the key drivers of mass incarceration. With our National Revolving Bail Fund, our community-based advocates, known as bail disruptors, pay bail for thousands of people who cannot afford to pay it. The Bail Project makes its payments directly to the courts, and our clients have no financial obligation to us. Our services are free. Bail disruptors then design a client support plan to help overcome any obstacles to court return. That plan includes ongoing communication, effective court notifications, and voluntary referrals to social services and community-based programs. At our Indianapolis site, for example, 66% of our clients tell us they need transportation support, and 64% have children or are pregnant at the time of their arrest. So we know that transportation and childcare needs must be met to ensure return to court. In Tulsa, 70% of our clients are unemployed, so employment and job training referrals will be a positive intervention here. We describe this work as the community release with support model, and every day we show that this works. We have provided more than 15,000 client bailouts at our more than 20 city sites throughout the country since 2018. And across the country, Bail Project clients return to nearly 90% of their court dates. And with this community release with support model, we're proving right our idea that a person will return to court without their money on the line. And again, as my colleague Insha said, with the right community supports in place, we know that people will return to court. And it is this model that the Bail Project centers as it works with colleagues and partners on the ground to push for systemic reforms that will steer jurisdictions away from cash bail and pretrial detention. When we consider systems without cash bail, I do want to caution us against using pretrial algorithms as a replacement. And we're not alone in that thinking. More than 100 civil rights organizations issued a statement of concern in 2018. This statement was led by the Leadership Conference on Civil and Human Rights. We know that pretrial algorithms, also known as risk assessment tools, while they give the promise to leverage science to promote a fairer legal system, they actually characterize people based on arrest and other criminal justice data that are already deeply tainted with racial bias. So as a result, pretrial algorithms are going to disproportionately mischaracterize Black and brown people as high risk, only perpetuating racial disparities. Instead, as the Bail Project's work demonstrates, the federal government can and should make investments into states and localities that want to first eliminate cash bail, making release on recognizance the norm. Second, make pretrial detention the rare exception, used only when absolutely necessary to prevent imminent violence or willful flight. Third, provide individualized hearings with robust due process protections in the limited instances when pretrial detention is sought. And finally, establish a community-based infrastructure for pretrial support to ensure return to court and prevent future encounters with the criminal legal system. Commissioners, the challenge before us is to reimagine what racial and economic justice might look like. And we have an opportunity to do that in the bail space. Thank you.
Thank you, Ms. Bennett. Mr. Troutman, we will hear from you. Please proceed.
Thank you for having me here today to talk on this issue. My name is Lars Troutman. I'm a resident senior fellow with the R Street Institute in Washington, D.C., where I work on criminal justice and civil liberties policy. Earlier in my career, I served as an assistant district attorney in Essex County, Massachusetts, where I gained firsthand insight into bail and pretrial practices through participation in hundreds of arraignments and bail hearings. We're brought here today largely to answer three questions. What is the state of pretrial justice in this country? How does money bail factor into that? And what are the implications for civil rights? The short answers to those questions are that the pretrial justice system frequently fails to live up to its name. Money bail creates and exacerbates many of its problems. And as a result, civil rights are regularly abridged and violated in this country. As you've already heard, at any given moment, there are literally thousands of individuals who are held prior to trial for no better reason than a financial inability to pay whatever money bail has been assessed on their case. What's more, there are many more thousands who are released, but only after significant financial hardship to themselves or their family, particularly through the payment of non-refundable commercial bail fees. What evidence we have suggests that there are significant racial and ethnic disparities, both in the amount of money bail that is set in a case, as well as who ends up detained prior to trial. To this, we also see wealth-based disparities. None of this should come as any particular surprise to the Commission, given that we are talking about an explicitly financial instrument in pretrial detention decisions, money bail, and a criminal justice system that is still marked by structural racism. Of course, we are going to end up with racial, ethnic, and wealth-based disparities. Targeting these disparities, especially through implicit and explicit biases, reducing and ultimately eliminating them, is imperative. But what I want to hammer home right now is that we could have saints working our pretrial justice system in this country and still end up with inequitable and unacceptable results. How can this be? Because the pretrial justice process in many jurisdictions is rushed and reckless. Studies have indicated that in some places, the typical bail hearing lasts only 1 to 3 minutes on average. That is hardly enough time to assess an individual's risk of flight or danger to the community, let alone their financial ability to pay whatever money bail may be assessed on their case. I can personally attest that when I was a prosecutor, on numerous occasions, I had to stand up and quickly familiarize myself with the case and determine my bail recommendation in the minute or two it took a court clerk to formally read charges to a defendant. That's a system that invites error and inconsistency, no matter how even-handed or thoughtful its participants attempt to be. At the same time, there's not nearly enough follow-through on these bail decisions. Although we often think of the problem of money bail as the $100,000 or $250,000 bail that someone can't possibly hope to pay in a case, oftentimes as little as $500 is all it takes to turn into a de facto detention order. And I would be willing to bet that in the overwhelming majority of those cases, the prosecutor who requested that bail and the judge who set it did not think that it was going to be a detention order. And so what that means is we have a system that's so thoughtless and careless that it essentially detains people by accident. And if that's not a violation of due process and civil rights, I'm not sure what is. The good news is, as I'm sure you'll hear over the course of today, that there are many state and local leaders stepping up across all 3 branches of government and in civil society to try to break our over-reliance on money bail. And it makes sense that this is where the energy would be, given that our criminal justice system is predominantly a state and local affair. But there's also an affirmative federal response that can and should take place to these problems. And I'd like to quickly address 2 of its components. The first being the grant programs that are available. Whether that's leveraging existing programs or creating new ones, these can incentivize and support local actors who are trying to find new ways to deal with pretrial release. The other major component is the Department of Justice, which has incredible research and technical expertise that it can provide to these local jurisdictions. It can also step in a monitoring and compliance role through its Civil Rights Division to help curb some of the worst abuses that we see. I expect over the course of this hearing today that we'll touch on this and a lot of other important issues. So I'm mindful of my time and just would like to thank you once again for including me as part of this discussion. Thank you.
Thank you, Mr. Troutman. The panel has been very, very helpful and has provided incredibly cogent information. At this point, we will accept questions from our commissioners, and I will call on our most senior commissioner at this meeting, Commissioner Yaki.
I hope you're not implying that I'm like really old or something like that. Thank you very much, Commissioner. Yes, in fact, this month I celebrated my 16th year on the U.S. Commission on Civil Rights, and have enjoyed what I particularly enjoyed these moments here. This is a very important briefing, and what was interesting about this first panel was how there seemed to be consensus on the idea that wealth-based bail is something that needs to be done away with. But there is not consensus, it appears, at least from some of the folks, about what exactly needs to be done. What I'd like to ask is, looking forward to the next set of panels, what programs are we going to be hearing from that you like the best? And I'd like each of you to sort of just take about 30 seconds and describe which one you like the best and why. Let's just start with Raphael.
So, it's a difficult question. I don't think we can say for sure that there is any one jurisdiction that has gotten this perfectly right. If I had to pick a jurisdiction that has gone about this the best way, I would choose New Jersey, insofar as the state of New Jersey has done a pretty good job of making monetary release conditions less and less common. And it has done that with the benefit of using RATs, risk assessment tools, that are algorithmic in nature. I know that there's concern about racial disparities in the way that RATs might contribute to those. One thing I would point out is that New Jersey's bail reform has been in place for a few years now. The racial compositions of its jails have not changed as a result of the application of those RATs. RATs, like the one that New Jersey uses, have been shown to be very predictive, not just across the entire pretrial population, but across races as well. There's a great study by the Center for Court Innovation that I would point you to. Now, it is true that sometimes those RATs might treat some races differently than others, which is largely a function of how much those RATs tend to weight criminal history, for which there is a disparity along racial lines. But it's not that they are more or less inaccurate with one racial group to another. It's that when they are inaccurate in different ways as to some racial groups. Okay. Again, putting those things in place may not necessarily be perfect. New Jersey certainly isn't perfect, but I think it has the best system in place to get us there.
Ms. Rahman, I saw you shaking your head.
I was shaking my head. And I appreciate Mr. Mangual's comments, especially that the jail population in New Jersey before bail reform was 54% Black. It remains 54% Black today. So while New Jersey has decarcerated by over 40%, they have not moved the needle on racial disparities. And one of the large concerns is the risk assessment is central to pretrial decision-making there. And it certainly hasn't helped with racial disparities, maybe hasn't made it worse, but hasn't helped. And the reason I was shaking my head is also, there are many jurisdictions that have done bail reform well that have not relied on risk assessment instruments, nor have they relied on excessive pretrial conditions for release. And New York is one of those examples. New York City has essentially done bail reform before formal bail reform went into effect in New York State. Across the past 20 years, New York City has decarcerated by over 60%. We literally have gone from having 20,000 people behind bars to about 5,000 today. And in that time, we have also decreased crime. And so one of the challenges is that so often bail reform is seen as pitting pretrial release and ending bail with public safety. And New York City is an example over the past 2 decades of how you can do both. Crime is, even given the last year, and an uptick in homicides and shootings, which are true across most major cities in this country. It's not just New York City, and most major cities have not done bail reform. We've actually seen that crime has consistently gone down here in New York City, as well as across New York State. And so in New York State, the bail reform that was passed and put into place in 2020 essentially expanded mandatory release for the vast majority of misdemeanors and nonviolent felonies, and allowed for money bail to still be set on violent felonies and other serious offenses, but with a consideration of ability to pay. We saw within the first several months of implementation that pretrial populations declined across the state by over 50%. The overall jail population declined by 40%, and there was no risk to public safety. It's a model that is cheaper than New Jersey, It is better for civil liberties of individual people who go through the system, and it also doesn't compromise public safety. So to me, I think New York is the best example we have so far. And the one other one I'll point out, Commissioner, is Illinois just signed into law bail reform this week. And one thing they did that is unique is that the risk to public safety element for considering detention, they narrowed it significantly so that the standard is that it's risk to an individual person or persons and a risk of physical harm, not just this broad standard that can encompass all kinds of behavior, including behavior that is not threatening or not risky at all.
Great, thank you. Ms. Bennett?
Yes, thank you for the question, Commissioner. What I will add to this discussion is the model that is going to work is going to be one that offers community supports. And I really want to encourage us to think, while we are discussing cash bail specifically, what I suspect you're going to hear from some of your panelists later this afternoon, particularly those who are serving on the criminal justice stakeholder panel, is that we really need a holistic review, a holistic response to our criminal legal system, and that the investments that we are making put people in jail pre-trial really should be made in those social supports that are going to keep people from engaging with the system to begin with. So if there are pre-trial models that, again, offer these supports like we have seen in San Francisco, where it's an independent, it's a nonprofit organization that is, offering case management, offering supervision, and really connecting community with the supports that they need to ensure that those who have been charged are appearing to court to face those charges, that is going to result in better outcomes, we know, with respect to court appearances, as the Bail Project work has demonstrated. And it's also going to result in a response where we ideally see a person has minimal or no interaction with the criminal legal system in the end. And so I want to, again, really drive home this emphasis on trying to really reimagine what public safety looks like and really think about how we prevent people from being engaged with the system to begin with. And in this context of cash bail, it really is about providing supports for people, an individualized assessment of a person. This is not just when we're figuring out whether or not to detain someone, it's also about figuring out what resources to provide that person.
Right. Great, thank you. Thanks for the shout out to my hometown, San Francisco. Mr. Troutman, the floor is yours.
Thank you. I think I would largely agree that if I had to point to one of the reforms that's working best, I would say New Jersey, but with the caveat that there are those stubborn racial disparities that are still there. So it's still a flawed reform in which there are additional steps that need to be taken. I would also counsel against treating risk assessments as a replacement for money bail, because I think that they ultimately address two different questions. A risk assessment is who should be released or not at its core, and money bail is a condition of release. It really has no part that it ought to play in whether somebody is released or not. And so I think for that reason, a lot of it comes down to what was just said about the supports in place. And one of the most remarkable supports that I've seen in terms of efficacy is a simple text reminder to defendants that those have been shown to increase the return to court rates. They're cheap, they're easy, they're non-invasive. And so it really can be something as simple as that comes into the void filled if we start to rein in money bail more.
Thank you. Madam Chair.
Thank you. Commissioner Klodny.
Thank you very much, Madam Chair. I have a bunch of questions. The first one is, I think, Ms. Rahman, you were speaking about crime in New York City. And later in the day, we're going to have Commissioner Bratton speak, which is, he says, contrary to what you say. I've read a New York Post article that says there was only one person who committed a crime while on bail in the first half of 2020. He comes with 2 weeks in September of 2020 after the amendment. and talks about burglary and robbery. I think second-degree burglary and second-degree robbery are a no bail thing. You get out on conditions or whatever. First, has anyone done a complete study of 2020 regarding remand, bail, and recommitting offenses?
No, nobody has yet. And we are in the process of doing that study. We have just released a report last week that looked at the impact of bail reform. But in 2020, as we know, there were a number of other sort of noisy disruptions to studying something that otherwise cleanly would be pre-bail reform or post-bail reform, namely the pandemic, and a number of steps that local counties and jurisdictions took across New York State to respond to COVID-19 behind bars. And so what we found is that overall, bail reform resulted in far fewer people behind bars, about 31% overall jail population decline. Some of that likely was driven by pandemic-related releases of bail hearings and things of the like. What we've also seen, though, in looking at the offenses for which bail is still eligible in New York State, is judges continue to sort of do their practices pre-bail reform, after bail reform. If they set bail on those kinds of violent felony offenses before bail reform, they were going to do so after bail reform. Interestingly, the one difference we found is that bail got set at higher amounts. And so that suggests an intention to detain using money bail on the offenses for which before they might have set lower amounts of bail, perhaps with more of an intention for the person to be able to afford it and to be released. So I know, Commissioner, that that's an unsatisfying answer, but my organization, VERA, is working on studying the impact of bail reform and explicitly studying the impact of mandatory release, including for offenses that sound scary, like second-degree robbery or second-degree burglary, both of which actually have no element of physical harm or injury to another person. Burglary in the second degree in New York State is entering into the common areas of a building with the intent to commit a crime therein. There is no requirement that there is physical harm or threat to another person. If there was that element, it would actually not be the kind of second-degree burglary where people are automatically released. And likewise, robbery in the second degree, the only provision that for which there's mandatory release is when it's acting in concert. As a public defender in the Bronx, one of the offenses I saw most often were two 16-year-olds who would grab an iPhone on the street, run past the person was not hurt, wasn't harmed, but it's a violent felony offense under New York law, and bail would often get set, those kids would be detained. And so the purpose of taking robbery in the second degree accomplice liability out of eligibility for bail was to make sure that we actually approached, especially those kinds of cases, with an eye towards supports in the community as opposed to pretrial detention.
Well, I think that'll be interesting to see if there's a reoffense quotient in those areas. The other thing I'd like to add, there's two other questions I have. One is, you've talked about risk assessment tools. We've actually tried to get our hands on some. Do you all have a copy of any of them? And can you forward that to us at the end of the briefing today? Is that good? Yes. I think that's a yes.
That is a yes.
The next question I have is, we spoke about preventative detention, and everybody speaks about it with an overview of, yes, we should have preventative detention. We don't in New York, I don't think, at least.
We do. It's limited.
But I never hear the elements of what should be included in preventative detention. So can y'all chime in and give me your favorite elements of preventative detention? Who wants to go?
I'll give it a shot. I mean, when we say preventative detention, I think what we're talking about here is judicial mitigation of risk, either risk of flight or risk of reoffending. In New York City, you can remand in limited cases for risk of flight. However, New York City judges actually do use RATs to assess risk of flight. Those are administered by the New York City Criminal Justice Agency. They just don't use algorithmic RATs to assess risk of community danger because they are statutorily prohibited from doing that. So I just wanted to correct the record on that front. But I think some of the most predictive elements of those tools are going to be things like age, criminal history, gang membership. The Center for Court Innovation here in New York has done a pretty good study outlining how a risk assessment tool might be used to assess risk of danger to the community using a lot of those factors. That study found that it would be very highly predictive, about 0.7 and above across all racial categories again. So yeah, I think it's going to be really those three things that are incredibly predictive of people's likelihood of reoffending, at least if we're talking about the public safety front. There are a lot more factors that will go into risk of flight, but with respect to danger to the community, it's largely going to be criminal history, age, things like gang membership, et cetera.
So what I will add to this discussion is that we really want to see due process protections provided anytime we are talking about taking away someone's liberty. And I want to direct the commissioners, and I will make sure that this is included for the hearing record, but I will make sure that the after cash bail report that the Bail Project has assembled, which goes through what due process would look like, is provided here. So when pretrial detention is sought, we want to see that a prosecutor is making a motion within 24 hours of arrest, establishing with clear and convincing evidence that the person that they seek to detain will engage in imminent violence or willful flight. These are the only factors that should justify a person's detention. We want at this hearing, we want to make sure that if there is a finding, again, that a person should be detained, that it is through clear and convincing evidence. And we also want to make sure that this person has had access to counsel. We want to make sure that this person has had access to evidence. We want to make sure that this person has had access to witnesses. And we want to make sure that this person has the right to appeal. So again, really driving home the fact that you're not going to deny anyone their liberty without very serious standards and robust protections put in place. And so I will add that to this conversation as you're trying to find specific things when considering preventative detention.
And I think I would second some of those procedural points where the typical bail hearing is really just argument from the prosecution and the defense. When we're starting to get into preventative detention, then there really does have to be much more of a hearing and opportunity for evidence, witnesses to testify, and a much more complete record to find that sort of identifiable harm that would necessitate preventative detention.
Ms. Bennett, oh, I'm sorry.
I will only add one more gloss to that. I agree with all the procedural due process protections. Preventative detention should only be considered for serious charges where there was an allegation of harm or risk to another person to begin with. Too often, bail that results in pretrial detention is used on low-level offenses, on public disorder offenses, on drug offenses. And as a society, we've seen that we can manage for low-level offenses in the community with a different approach. So that's the one other consideration. And we've seen a number of states move in that direction, including New York, what was just passed in Illinois, in Harris County, Texas, where we've worked as well. Essentially, all misdemeanors and some nonviolent felonies are automatically released. One other thing I wanted to clear up, Mr. Mangual, is New York State's bail reform does not mandate the use of risk assessment tools in the way that New Jersey's does. That's what I was referring to.
So when you were talking about due process for bail hearings, I've actually done a few in my life as well. And they are short and sweet and right away. My question comes, when you're asking for all that information, Ms. Bennett, prior to a bail hearing, and obviously right to counsel, do you expect that to occur within 24 hours? I mean, where I see people really having problems is getting arrested on Friday night Most magistrates won't hear you till Sunday evening, and probably on jail video without counsel. So how is this just a matter of staffing up all these jails around the country?
Thank you for that. And yes, we do expect there to be this hearing, this consideration made within 24 hours of arrest. And that may seem daunting, but again, to the point that has been made by some of my colleagues here, the reality is that we ideally are going to divert most people away from custodial arrest, that we are going to cite and release most people, and that is going to dramatically limit the number of people who are brought into a jail, there with the likelihood of being there over a weekend, being over there for more than 48 hours, before consideration is given to whether or not they're going to be detained pre-trial. And so, yes, that is the standard, that is the expectation we should be setting for ourselves.
And one last question, because I'm sure Commissioner Degbelet would like to ask a few, as well as Commissioner Cantu, although I do like asking all of them. I forgot what it was. We're going to get a copy of that risk assessment thing. Is there another way of doing it, like interviews, where pre-trial people interview people who are arrested? And also, one other question is rearrest while out of custody for a serious offense, like burglary 2, robbery 2, a gun offense, things like that. How do you want to handle that?
I'll take a shot at that. I mean, I think rearrest, particularly for serious offenses, I think judges ought to have the discretion to completely revoke release conditions and remand defendants to pretrial detention once they've violated the conditions of their release in that way. New Jersey's bail reform statute does allow judges to do that. One thing I would just address really quickly is this idea that remand should only be an option for those facing serious charges. I think that's misguided, and the reason I think that's misguided is because the data seem to pretty convincingly show that the instant offense that a defendant is facing is not a particularly good predictor of their likelihood of reoffense in the future. In fact, the New York City Criminal Justice Agency, which administers the flight risk assessment here in New York City, did a study finding that the likelihood of failure to appear and or rearrest for a violent offense was actually lower among defendants initially arrested for felony level violent and property offenses. In contrast, the odds of pretrial misconduct were actually higher among defendants initially arrested for all types of misdemeanor or lesser offenses, with the exception of those arrested for violent offenses. So I think the reason this is because criminals tend to engage in a pretty wide variety of criminal behavior. The idea that they specialize, I think, has been shown by the data to be not correct. And so it is because lower level offenses are committed at a higher rate, they're more likely to appear before judges facing lower level charges. And I don't think we should hamstring the system by taking detention off the table simply because the instant charges being faced are low, particularly if that defendant has been shown to be high risk.
I would similarly caution against using a particular offense to guide too much of these determinations, whether that's revocation or who's eligible for release, simply because so much of that rests with the discretion of the prosecutor. You can give me a fact pattern and I can make that a misdemeanor, I can make that a felony, I could probably make it 2 or 3 of each if I wanted to. And so I think that there's a problem if we rely on the offense to do the work for us versus actual individualized examination of the facts of the case, who this person is, what the actual risks are, because the offenses themselves, you can play a lot of games fast and loose with those.
And I'll just add that we always want to make sure that anything that we're imposing with respect to a person's return to court reflects the least restrictive conditions to ensure that appearance. To the question about needs assessments, which is what I believe Commissioner Gladney you're touching on. I think that's exactly right. I mean, we want to make sure that we are figuring out what supports a person is going to need to return to court and provide those things. So I just wanted to make sure that that was a piece of this conversation. Thank you, Commissioner Cladney.
Thank you all in answering Commissioner Cladney's questions. And we have a little bit of time for Commissioner Degville to also pose questions. Please proceed.
Thank you. I'm interested in first, thanks for your testimony. It was all very thoughtful, and your responses to the questions have added to the record. So we're grateful. My first question goes to sort of the state of play. We're really thinking about this on two levels. There are federal issues, and I'll come to a question about federal reform. But then, as you have described, lots of the action is in the states. And the thing that I'd like for you to level set for us on is how widely accepted are the empirical criticisms of the existing system that each of you has put out there in some substantial detail, meaning how much action and activity is there on the ground to take note of the injustices, inefficiencies, and disparities of which you speak?
So I can begin by saying I think there is growing consensus, as illustrated by four fairly different folks on this panel, that we can eliminate money bail and for-profit bail, and that it is harmful. I think that across the board there is widespread consensus, and that's not where the hard work is. I would say the hard work is around pretrial release, and to the extent that we can limit pretrial incarceration. How do we go about doing that? And how do we invest in the right supports, both for supporting people during pretrial release and thinking through due process for preventative detention or pretrial detention? That's where I think the rub is, and that's where I think we actually don't have great models across the country. You spoke of the federal system. The federal system was one of the first to eliminate the use of money bail and also to include risk to public safety as a basis for pretrial detention. We've seen in the past 30 years that preventative detention on the federal system has gone from less than 1 out of 3 cases to upwards of 2 out of 3. I think the federal pretrial detention rate is somewhere between 65 to 70% of cases are detained preventatively. That's not the system that we want to replicate across the country. Even though they've eliminated money bail, we have not eliminated the excessive use of pretrial detention in the federal system or in other places that have a widespread preventative detention scheme.
So I would largely agree with respect to the idea that there is a growing consensus that there are serious problems with systems that rely heavily on cash bail. I wouldn't go so far as to eliminate it entirely, only because I can envision cases in which you can successfully mitigate risk only through the placement of monetary release conditions that would hinge on a defendant's behavior. I'd like to leave that option available as opposed to the only option being remand. But I think there's large agreement there. One thing I would just say about the federal system, I think we have to be cautious about how we compare rates of pretrial detention in that system compared to state systems, which is really where the action is, in part because of just the nature of the charges that federal defendants are going to face. Those are different. They're likely facing longer sentences. They're likely involved in cross-state activity, which makes them more of a flight risk. So there are a lot of reasons why you might see higher rates of detention in the federal system as compared to the state system. But that's really where the rub is. And I don't think we necessarily have great answers. Like I said, I would point to New Jersey as probably the best formulated reform that has been done so far. But I do think that where the federal government can really make a dent here is to help fund state systems. I mean, the reason that we're all talking about bail reform today, again, is because of how much time people stand to spend in pretrial detention. That is purely a function of the resources available to those systems to process cases. It should not take 3, 4, 5 years to get a case from filing to disposition. The reason that that's the case is because we've crowded out the money that we have to spend on that core government function. And helping to close the gap is something that I think the federal government can easily do. I think that money would go toward a good use. And I think that's the most direct route to addressing the concerns that surround pretrial detention, particularly lengthy pretrial detention.
I agree with my colleagues that there is certainly consensus across the ideological spectrum around this need for bail reform. I think Insha is exactly right. I think, and as we heard from our colleague Raphael, there is certainly disagreement in terms of what specifically that reform should look like. And again, sort of what the due process protections should look like in a bail hearing, when preventative detention will or will not be appropriate. So yes, I certainly look forward to working with everyone on this panel and those who will follow us later today to figure out what those solutions are. I will add that you also see this agreement reflected in the legislation that's being offered in this Congress and was offered in the past Congress. We have members on both sides of the aisle who are doing exactly what Raphael said, providing grant assistance and other federal resources to states and localities that want to reform their money bail systems, and giving states and localities the ability to figure out what is going to be the best reform for them. And so want to continue those conversations, want to make sure that happens. On the federal level, I will push back a little bit and say that we need to have reform at the federal level as well. And obviously federal lawmakers, the Department of Justice are well positioned to take a look at their own system and figure out what failures with respect to the Bail Reform Act need to be corrected. And I would offer that these presumptions of detention that we see often for drug offenses is one place to start. We have seen, again, members on both sides of the aisle try to take on that presumption, the presumption around drug offenses, and eliminate that. There are other presumptions we'll want to consider as well, but with respect to drug offenses, that is a good first start. So want to make sure that we know that there is a lot of work cut out for us, that we have an opportunity to work across the aisle, that we have the opportunity to work across organizations, really encourage us to do that with respect to local, state, and federal pre-trial and bail issues.
Just very quickly, Mr. You mentioned that something as simple as a text has been shown to have some positive effects on getting people to return for their hearings. Is there data on the efficacy of the text, and what's the best source of that data? And then separately, are there things short of large cash investments system-wide that can be difference makers? This question is not intended to resist the point that you're making, that federal investments and other investments are an important piece of the solution. It's just that in a world where sometimes people can use tight budgets as a reason for stasis, I just want to know what the other things are that can be added into the mix and perhaps move the dial.
Yeah, there's a study that we can certainly forward along to the commission that shows the efficacy of those text reminders. And I think that really just points to one of the big issues where a lot of times when folks don't show up to court, it's not some willful flight, skipping town, it's they just forgot. People have a lot going on. In a given case, you might have a dozen court dates over the course of the year. And when those are scheduled, you may have very little input on when that falls. So I think that there are a lot of steps that we can take simply to remind people and to help give them that nudge. It's the same thing we see with a dentist telling you, and it works for them, it works in the justice system.
And go ahead, Insha.
There's a specific study out of New York City that found that failure to appear rates declined by 26% based on text notification. So we'll share that as well. To answer your question about what can be done short of money, a dear colleague letter encouraging states to expand mandatory release. The state of Kentucky did it earlier in 2020. The jail population declined by 25%. Public safety has remained the same. It doesn't cost the state anything. It's actually saving counties money because there are fewer people behind bars in local jails. That's a way to free up some resources at the local level, because it is the states and localities that are paying for our pretrial system as well as our jails, which are the most expensive part of the pretrial system.
If I could just really quickly, I'm sorry.
No, I just wanted to add that with respect to the bail project, we rely on text reminders and have data that we can provide to this commission that will show that, again, with our more than 15,000 bailouts, we know that 90% of court appearances have been made by those clients. And then with respect to your other question around what can we do that doesn't require this heavy financial investment. I will suggest that when we detain less people, we will have money to invest in some of these social support. So it is a cost savings. Want to stress that. And then to Incha's point about the Dear Colleague, the federal government also issued a Dear Colleague a few years back, encouraging localities to not rely on unaffordable bail. And we would love to see something like that reissued again, modeling to states and localities why this reliance on excessive bail is in violation, inconsistent with the Constitution.
I just wanted to very quickly say that I think there is very encouraging evidence about electronic reminders and the success, but I should just note that the research on that is a little mixed. There was a study in 2018, the American Journal of Criminal Justice, that focused on the efficacy of those notifications, specifically on those rated high risk of flight. Unfortunately, that study did not find positive effects of the notification system as to that population, which kind of reinforces the need for validated risk assessment tools in conjunction with these notification programs, which I do think are a good idea.
Thank you. And I would agree that relying on technology, being in Texas where we lost electricity for several days, is only one of many solutions to the problems we're discussing today. I want to thank all the panelists. You have actually consoled me. Our family mourned the loss of Edward Lee Cantu back in November. He was in the sheriff's department. He was a detention officer, and he died of COVID. And so what you all are talking about today offers comfort to families of folk who are in detention and also the employees who work at the detention centers. And you offer us hope. So I want to thank panel one, and we're going to take a brief recess for 15 minutes, and we'll join panel two. So goodbye.